All right, good morning, everyone. We will just give a little bit more time for everyone to get in from the chat or from the waiting room. All right, I think that's probably good. Okay, good morning, everyone. Welcome to our weekly Zoom Q&A. Just to go over the housekeeping stuff we do as normal. Remember that this is general legal information. It is not legal advice. So anything we say, even if you submitted a question, our responses are not specific to your specific situation, and don't take it as legal advice. Please keep in mind that the chat function during these Q&As is intended for questions or requests for clarification, and commentary in the chat is not legal advice. Please don't get into a full discussion as you would see on the CAI message board. You are pretty good at that, so we will move on. Our normal weekly update that the CTA is still being challenged by the national CAI. We still recommend waiting until later this year to comply, and we will keep giving updates as we have them on the status of that. The 2024 changes to RCW 6490 and the other statutes are now live and shown on the legislative website, so you don't need to keep referring to the bill number. You can just search what you're looking for and they are all updated. And as a reminder, there is no Q&A on August 14th. And I forgot to mention that if you have any questions that come up during this Zoom Q&A, you can put them in the chat. Chelsea should have put a message, she did, with more information about our Zoom link, or sorry, the YouTube link. And if you don't see it, it's flashing at the bottom of your screen likely. So that's where you can put messages. And with that, we will just jump into it. Our first question today is, how should HOAs treat non-owner occupied units that are occupied by relatives of the owner? Do you treat and count it as a rental? What about insurance? Can we require the owner to carry landlord insurance and provide the HOA with proof of landlord insurance? So the answer to the first part of this question largely depends on what your governing documents say. Some documents will state that units occupied by the owner's relatives are not rentals or do not count towards a rental cap. If your documents are silent, it's likely that the relative occupant counts as a rental, but you can really pick any method of defining a rental, because where it's important is the self-reporting by the association for basically banks when they ask questions about who is in rentals and whatnot. So you can put in a definition that a parent of a child or a child is not a rental. You can do it with a rule. You can amend your declaration to say it more clearly as a definition. It really doesn't matter except for terms of the banking industry and not wanting to exceed rentals of 50% of, or occupied units of 50%. And regardless of the status of who occupies the unit, owners are still responsible for making sure that their tenant, their family member, their guest follow the rules. So you treat them the same as any other person if there's a violation or a complaint. If your documents are silent, you likely cannot require certain insurance or proof of insurance, either that the tenant have insurance or even that the owner has their own insurance, whether it be regular insurance or landlord insurance. We don't know what landlord insurance is as defined by this question, but typically it's the same as a homeowner's policy, but without any coverage for personal property. Landlord insurance protects the physical property, the home or the unit, and provides liability protection for the landlord. It wouldn't do anything to protect the personal items of the tenant, and the tenant usually buys renter's insurance. That's not done by the landlord. Some governing documents do require that tenants have insurance, so there may be liability coverage for the bad things that the tenants do. But like I said earlier, if the owner is still primarily on the hook for the acts of their occupants, tenants, relatives, guests. Ken, anything you want to add to that?
Yeah, the idea that the landlord insurance is going to provide any kind of protection for the association is probably false because um, a regular homeowner's policy doesn't provide any protection for the association for bad acts of the owner. So the landlord's policy won't do anything better than that. So, traditionally, because the property insurance is covered by the association for a condominium, the landlords would just not bother to buy any insurance. Now, we do when we redraft declarations, we require that landlords buy insurance that also would cover loss of rent for them and liability for the actions of the landlord. And we also require that tenants have insurance so that there would be coverage for bad acts, which the tenant might do, like if they were to overflow a sink and damage the building, then they would have insurance to help offset the loss for the association. Next question. Could the insurance deductible be increased, and then would the homeowners be responsible for the new deductible, or would they be responsible for the deductible at the time the incident occurred? So if you have language that allows the association to shift the insurance deductible to an owner, then they're only responsible for the deductible to the extent that the owner knows what the deductible is and that it is provided for in the declaration. You cannot increase the deductible after a loss or occurrence in order to try and shift more cost to the individual owner. Insurance is always measured on the date of the occurrence. So if the loss occurred in January and you increased the deductible in March, whatever the deductible was in January is what applies to that particular loss. We have seen some concerns where associations have increased the deductible, and they've done it at a board and management level and not bothered to tell any of the individual owners. And so we've had claims where the owner had purchased the $10,000 of insurance because that was the deductible that they were told about. The association increased the deductible to $25,000 without telling them. So there was a gap of $15,000 between the coverage the owner had and what the association wanted to assess to the owner. And if you have not told the owners that they have to have the higher limit for the insurance, then we think it's going to be difficult to obligate them to pony up the extra money. So the other thing that came up out of this, or I was reminded, was that some condominium declarations have written into the insurance section a maximum deductible for the association's property policy. And I happen to have one this week where the maximum deductible was $1,000, which is ridiculously low in our current insurance market. Now, in that particular association, they cannot make a unit owner pay any of the deductible anyway. So if they, as a board, choose to increase the deductible to $10,000 or $25,000, the risk is all being borne by the association, and the board could balance the risk of having to pay that additional deductible against the savings which they are going to get by having an increased deductible. But if you're trying to make owners pay, it is incumbent upon the board to make sure that every time you change the deductible, you give good notice to the owners so they can confirm that their individual policies will provide for their obligation under the declaration. Anything you want to add, Katie?
Nope. So the next question is, you mentioned last week that there were some other bills that passed and changed in things in 6434 and 6438. Can you let us know what the bill numbers are for those? So as I mentioned at the beginning, the new statutory numbers have been updated on the website, and I will put them in the chat. For RCW 6434, there were changes to the occupancy limits and heat pump restrictions. Basically, you can't set an occupancy limit in your governing documents, and you can't prohibit heat pumps in certain situations. So the statutory language has been updated. It's RCW 6434-399 for occupancy limits, 6434-393 for heat pumps, and then RCW 6438-170 for occupancy limits in the HOA Act, and RCW 6438-180 for heat pumps. RCW 6438-057, which talks about a prohibition on regulations for drought resistant landscaping, among other things, was also revised to allow pollinator habitats and including beehives on the list of things that an association cannot prohibit in the governing documents. Anything to add, Ken?
No, I think I'm good there. I do think that I don't know that Ukiah was updated in the same way. And there are also some changes to the foreclosure statutes, I believe, that don't get reflected in the homeowner association statutes, but would still apply to foreclosures by homeowner associations. Next question. We're having problems involving our board members. Currently, we do not have a board president. How important is it to have a president? Okay, so I'll offer we have a debate in our own office about whether or not having a board president is important or not. There's certainly some things which theoretically only a president can do, like maybe signing an amendment to your declaration. And banks might require that you have a treasurer and president. The Secretary of State certainly thinks that you're going to have a president and a secretary, but you can just put board member on the Secretary of State. I've seen that. So the questions become really ones of how you operate as a collective if you don't have someone who is sort of directing traffic as the board president. One of the primary goals of the board president is just to manage the meetings. They conduct annual meetings, they conduct the board meetings. But if you're a small board and you work collaboratively and you make decisions by consensus, I certainly know I have clients that do not have a designated president. And I have at least one client that specifically avoids designating a president for fear that they are going to empower somebody to do things that they shouldn't. So in terms of trying to engage, one thing you can try and do is make life easier if you have consultants or managers who are performing more of the busy work and collecting information for boards to make decisions. That might allow the owners to participate more because they're not having to gather the information. They're just having to make decisions when information is presented to them. Let's see, what else? If you do have a consensus form of governance, and we do have some clients that, every member of the community or every member of the board is equal, and they just have a different method of conducting meetings than to do the Robert's Rules of Order form, then what it comes down to is at some point you just need to have somebody with authority to sign. I have some clients where they will, on a contract, just put every board member's name on the signature line and every board member signs. So there's not a question about whether or not there is authority to enter into the contract. Yeah. Anything you want to add on that, Katie?
No, you covered it. So the next question is, we just found out that a new homeowner is on house arrest. They have a very long and concerning rap sheet. I am assuming there's nothing we can do about this. The board is wondering if they can require a background check on future owners. I'm assuming that would not be allowed. Your thoughts? So we cannot answer this for your specific situation, but generally you are correct. There's nothing you can do to require a background check of potential owners or prospective buyers. Some communities may be able to do this if their governing documents allow it, or if there's another sort of agreement that would allow it, like they're a co-op or something like that. But for the standard association, it's probably not allowed. And the judicial system has said that the public is adequately protected with this person being on house arrest. So just because they're under house arrest and in your community does not necessarily mean that they are a risk. I mean, obviously, if there's a real threat and something happens, like normal, even if they weren't on house arrest, call the police, they're still responsible for their behavior. You can find violations, etc. The statutes do allow the association to require tenant screenings. This is not for potential owners. This is for tenants only, and the association does not get a copy of the report, just proof that it was done. Again, it doesn't apply to potential buyers. And even if the board could require a background check on a potential buyer, we don't know what you would be able to do with it. You likely would not be able to prevent the person from living in the community. You would just have the information, which is already likely publicly accessible. And keep in mind, in the city of Seattle, a criminal record cannot be used as a criteria to reject the tenant. So you probably couldn't use it to reject an owner or another occupant. Ken, do you have anything to add?
No, I think you've covered it. Next question. Are we required by law to notify owners of condo board meetings? Are they allowed by law to attend, if only to observe, unless they are on the agenda for comments? We tend to have ad hoc rather than scheduled meetings, so notification tends to be about 1 week ahead. Our condo association was founded in 1986. Our governing documents are silent on this. Okay, so again, we'll give our disclaimer. We can't give specific legal advice without reviewing your documents, even if you tell us the documents are silent. So the answer for condominiums in Washington State today, which means you're governed by 6434 or 32, is there is no open meeting requirement in the statute. And so you are not required to give notice to owners because you're not required to let the owners attend. If you are subject to 6438, the Homeowner Association Act, or Ukiah 6490, there is an open meeting requirement, even if your documents are silent on it. The statute Ukiah 6490-445 subsection 2F specifically calls out that owners must be given notice of every board meeting, the same as the board members get notice. And they require 14 days notice if it's not included on a schedule provided to all owners in advance. Now, there was an amendment to Ukiah in June that provides for some emergency meeting authorization, but it also defines what qualifies as an emergency. And so just deciding you want to hold a meeting is not going to be able to qualify as an emergency. And so associations are going to have to get better at planning their meetings in order to conduct their business instead of doing things ad hoc. In at least one state, the courts did find that a failure to notify owners of the board meetings was a failure of the board to comply with an open meeting requirement. So intentionally failing to notify owners would be, I think, a violation of law in Washington State as well. One of the other things which Ukiah does, which is not included in the Homeowner Association Act for open meetings, and is usually not included in open meeting requirements within condo bylaws, is an owner comment period. So be prepared that when Ukiah hits you, you will be required to have an opportunity for owners to have comments and address the board during the course of a board meeting. That doesn't mean they get to participate in the discussion. It typically would mean that you hold a period of time at the beginning or end of the meeting where owners can address any topic they would like to the board of directors. The board of directors doesn't have to respond to it. You don't have to answer questions, but you have to give the owners an opportunity to comment. Okay. See if there's anything else. Anything you want to add, Katie?
The only thing I'd add is that I don't think we can stress enough the need for looking down the road for future organizational and maybe standing meetings, because if not providing notice is a violation of the open meeting requirement, it's easy to get around that by just having a standing board meeting once a month where you send out the Zoom link to everyone and you have the dates, so all the owners have notice, and then the board can meet. If there's not a lot to discuss, it's a short board meeting, but at least you've already provided the notice and given people an opportunity to attend and meet that open meeting requirement.
And
Okay.
actually, I'll add, you can have meetings in person. And we know we have some clients who've gone back to in-person meetings just to make it less likely that owners are going to attend. I guess that's okay. Though we did have a client where an owner with a disability requested the ability to attend via Zoom or telephone as an accommodation for their disability. And our recommendation actually was that the association should accommodate that requirement. So it's a sort of continually evolving landscape on how to conduct the meetings. Sorry.
Okay, our next question is, our client is considering involving high schoolers in serving on the board or the ARC. They often require a school project to serve their community. Is this a good idea? Is there an age limit for such positions? So we can't say whether or not this is a good idea for your community or not, but we could see some benefits and some risks. If you're looking to involve a high schooler by having them elected to serve on the board, they would still need to meet the eligibility requirements for that of any other director that are contained in your governing documents. We don't think, or at least we haven't seen, a restriction on age for board members, but from a practical perspective, the owners would still need to elect the high schooler to serve on the board. There are some committees other than the board that may be more appropriate for this community involvement. There are some concerns about letting a teenager, especially under like the age of 18, serve on the board. They usually don't have the same life experiences as adults. And we don't know if there are any insurance risks that would be implicated for the acts and omissions of a minor. It may be better to have them sit in and observe the board meetings and not the executive session, and work on other things that are more appropriate both for their time commitment and their age. The board could ask them to spearhead a project. We would caution against letting them take charge of a big construction project or something with more risk. But if you're looking to rewrite your rules, that may be an appropriate thing. I served on a lot of community committees when I was in high school, so my perspective is a little different, but 16 seems like a reasonable age. Given the person, if they want to start getting involved, it may be that if they're just observing, 14 is reasonable. It's all going to depend on what the board's comfort is, what they're doing. If they're just sitting in, it's relatively low risk anyway, so it doesn't matter. But we would recommend if they're just observing or they're spearheading a project, there also be some supervision, as it will impact the whole association. Ken, anything to add?
Well, I'd be surprised if your high schooler is going to want to make a commitment to actually fill a position for a year. I think
Right.
they're going to want to do the 10 or 12 weeks required by their high school and then get out of it. So, trying to define a project for the high schoolers to do for the benefit of the community would probably be a better way of incorporating their assistance. Next question. I was writing to inquire if your group has put together any sort of recommended verbiage for management companies on informing association boards about the new requirements of the Corporate Transparency Act. If not, could that question be added? So we've talked about the Corporate Transparency Act many times. Our advice today is still to wait because we know that National CAI is challenging it in court. We know that it has been challenged and is in the U.S. appellate court system currently. And we also know that there's going to be a lot of efforts in Congress to try and get the act revised or get the act delayed, and those might be successful as well. So otherwise, the advice is that it's going to apply to almost every homeowner association, and that the board members and the association are going to have to comply. And there are potentially fairly significant penalties which go to the individuals who fail to comply. But there's just a lot of uncertainty around it, and we don't see a reason to rush into compliance yet. And then there is a method of reporting, having individuals report to the federal government their private information so that you do not have to give it to your association. So if your objection is just that your neighbors might know your social security number, you can get around that and have the information just go to the federal government. And then so that's one thing we have learned about it. We've also pretty much learned that there is no exemption for homeowner associations. The IRS is very clear in how they define what a 501c4 organization is, and that is an organization which is for the benefit of a community. But the IRS has made very clear in a published ruling that community in their definition is not the same as it is for community associations under CAI's definition. So when they say community, they mean members of the public, not a group which is defined by the ownership of property within a community. So I would say we have no real advice at this point. Maybe we'll have something that we can give more direction in October or November. Anything you want to add, Katie?
Nope. So the next question is, if an HOA attorney represents an association, can a homeowner in that association pay the attorney separately to review the HOA documents? Or would that be a conflict of interest? Our answer is it would probably be a conflict of interest, and no, a homeowner could not pay separately to have the association attorney review the governing documents. Our office would not provide legal advice if an individual owner or its board members, or if to an individual board member, to an individual owner, if the association is our client. That would also extend to a board member acting in their individual capacity. We would not advise board members in their individual capacity. The association is our client. Even if it's not an actual conflict, we wouldn't do it because it may turn into one. It might be a potential conflict. Owners or individual board members could ask the board as a whole to send us the document for us to review and for our advice. But if an individual owner is looking for someone to review their governing documents, they should contact their own attorney. Ken, anything to add?
No. Next question. What would be the consequences of not amending our CC&Rs to conform with the revised Ukiah? So the consequences of not amending are just that there may be conflicts between your documents and what the law requires. So, for example, the open meetings we've already talked about. If you're a condominium association, you'll be required to hold open meetings, even though it is nowhere in your documents stating that you're required to do so. Okay. And by January 1st of 2028, every condo association is going to be under Ukiah. There is no requirement that you update your document when the law changes. Okay. When the Condominium Act took effect, most condo associations in existence did not revise their documents. When the Homeowner Association Act was implemented by the legislation in 1995, there was no rush of all of the existing homeowner associations to run out and amend their CC&Rs. The laws still apply to them, but they did not bother to change their documents. So, some attorneys, and Valerie in our office is one, strongly recommend that you revise your documents to have them comply with the new statute, because it is easier to deal with homeowners when you can point to a single reference point, and that being the CC&Rs and declarations, and it requires what is the state law. But, I would say that the vast majority of associations have not amended their documents to comply with the Condo Act or the Homeowner Association Act. So I expect of the 8,000 or 10,000 communities in Washington state that a fairly small percentage are going to amend their documents to comply with Ukiah. There are a lot of reasons to amend your documents to take advantage of parts of Ukiah, such as being able to shift insurance costs or, costs which are not covered by insurance onto individual owners so that they have insurance to cover it. But there's nothing, there's not going to be any force compelling associations to spend the money. If you are a relatively large community, and by relatively large, I mean something in excess of maybe 40 units, then the cost of updating your document starts to become a relatively small cost. I would say, we generally budget in the $7,000 to $10,000 range for our clients to update their bylaws and their declarations or CC&Rs in order to become, completely up to date with modern practices and comply with Ukiah. And if you've got a community of more than 40 or 50, the cost starts to be a relatively small expense and can be absorbed in your budget pretty easily. So it's still a decision the boards need to make. You're balancing the cost against the benefits. And usually we would say if you've got other reasons to update your documents, like you want to condense the 13 amendments back into a single uniform or unified document with your declaration, or you want to clarify maintenance and repair obligations, or you want to share the risk of insurance, or if you want to take advantage of the ability to assess costs for misconduct against owners, then you'll need to amend your documents, because even with Ukiah applying and stating that you can assess costs for misconduct, they amended the statute in June so that in order for you to assess the cost for misconduct, the document must clearly state that an owner may be required to pay for expenses for their failure to maintain something or for their misconduct. And I would say that almost none of the documents that were written prior to 2020 are going to have clear language to comply with the new statute language that would allow you to shift the cost to the individual owners for failure to comply with maintenance standards, failure to replace your hot water heater when it fails, failure to, have smoke detectors, whatever it is. So it is not just that Ukiah is coming to be your controlling statute. It's, do you want to take advantage of how Ukiah can allocate costs between owners and the association? And that's the amendment you really need to make, not the adoption of all the Ukiah standards. Anything you want to add, Katie?
Nope. So the next question is, if a homeowner already has 8 liens against their home for non-payment of sewer and garbage charges, what options does the HOA have to collect an annual assessment of around $250 from the homeowner? And they have not already tried speaking directly with the homeowner. So first, we're not clear about whether the 8 liens are by the association or from a garbage utility provider, which in your specific situation may end up changing the answer, but we're not going to get into that. You can either hire an attorney or give the account to a collection agency. There are risks with going to the collection agency. They will likely charge you a substantial fee, or they may keep most of the money collected. An association attorney may be able to collect the liens and the unpaid annual assessment before it gets out of control. The association attorney will also know the specific notices that need to be sent under the statute. You can look them up by just Googling your specific statute. The required notices are actually included in the statutory language. A collection agency may not follow these specific statutory requirements for this kind of debt because they do all types of debt. You could also try asking the owner for the money before you take any collection effort. It sounds like this is a relatively low amount, so that may be a good place to start. But keep in mind, foreclosure and an association attorney is not the only way of extracting money from people. You could try and get a judgment from a court that can be enforced against other assets the owner has, or garnish wages. You may be able to get a judgment in small claims court, especially if the amount owed is this low. And if there are any services provided by the HOA, you may be able to discontinue those services because they are not paying. Ken, anything to add?
Yeah, I would be surprised if there really were 8 liens, because that would mean that somebody had paid to record at something in excess of $200 for each of those liens, the documents with the county. And so there's a lot of sort of questions raised for me on this. We would normally be looking at some kind of a communication with the owner as the first step before a lien would be placed on a property. So I guess this is something where you might want to talk to an attorney and give them the specifics about your case so that you can get some actual legal advice. So next question, what is the suggested way for a board of directors to get ready for the new RCW regarding or governing condos in Washington State? So I'm going to assume that this is again referring to Ukiah 6490, which will take effect for everybody on the 1st of 2028. Suggestions are, try and get informed and educated. We think our Q&A is one way to do that. The events through the Washington State chapter of CAI, like CA Day in October, would be good options. We think it would be reasonable to talk to an association attorney about what they might recommend for your association specifically. In other words, having your documents reviewed to find out what conflicts there are between the new statute and your documents would be valuable. So if you need to have open meetings and that's not in your documents, someone should tell you. If your documents call for 3 days notice for a board meeting and the statute says 14 days, it would be good to know that. And so that's where the biggest help could come from, is having a review of your specific documents in order to identify the conflicts. The other things that an association could do would be to hire a management company, which is familiar with the new laws and is practiced in complying with them. Anything you want to add, Katie?
The only thing I'd add is WSCAI has a legislative action committee, and in terms of the changes that will probably happen between now and 2028 with Ukiah, you could get on their mailing list to get regular updates on what's happening in the legislature. I think you can just do it through the WSCAI website, but that's another way of staying up to date. This next question is the last one that was submitted in advance, and we will likely have time for questions from the chat. So if you want to start thinking about those now, feel free, and we'll get to what we can with what comes in. So this question is regarding the occupancy limits that were just adopted and became effective. And the question is, do you have any comment on the applicability of the building code to this situation? Per the Seattle Building Code, as this question is asking, the occupant load for residential use is 200 square feet per occupant, which could come out to basically just under 5 occupants per 2-bedroom unit. So from the get-go, we did some research into the Seattle and King County Building Code, which basically both say the same thing, which is different than what this question asserts. And those two building codes state that dwelling units must not have less than 120 square feet of floor area, and sleeping areas must have a minimum of 70 square feet with an additional 50 square feet for each occupant in excess of 2. So it appears to allow 2 people to live in a 150 square foot dwelling and only require an additional 50 square feet per additional person, which would not come out to just under 5 occupants per 2-bedroom unit. It can end up being a lot more. But going to the base of the question regarding the statutory changes on the occupancy limits, RCW 6490-575, which is the Ukiah occupancy limit language, it's mirrored in the new act and the HOA Act, at least, which I have already put in the chat. But the statute says that except for occupancy limits on short-term rentals and any lawful limits on occupant load per square foot or generally acceptable or applicable health and safety provisions as established by an applicable building code, city ordinance, etc., a unit owners association may not adopt or enforce a restriction, covenant, condition, regulation, etc., provision of a governing document or master deed that regulates or limits the number of unrelated persons that may occupy a unit. So basically, if the Seattle or King County or whatever your building code says you can have 2 people in 150 square feet and 1 person per 50 square feet. In addition to that, you can't have a restriction that would be less than that. So my math is going to be probably bad, but if your unit is 900 square feet, that means you could have roughly 8 people. They can be unrelated. There is no requirement in fact, you cannot require that they be related under the new statute. So there's no distinction between related and unrelated parties under the building code, and so the association cannot require that the occupants be related. Ken, do you have anything to add?
Yeah, I think the legislature, without spending a lot of time on this, was trying to pass a law to allow more homeless people to be housed. And the idea being that homeowner associations have a lot of empty bedrooms, and that it is the evil homeowner associations that are preventing unrelated people from moving into these empty bedrooms and having housing. And so it is specifically about unrelated, so that basically means you can't have limits on roommates, you can't have limits, I think, on subleasing anymore, or you can't have limits on leasing individual rooms because those all seem to relate to unrelated persons dwelling in the same home. And it's a little unclear. And then the legislature did sort of throw in a exception, which is, well, if there's another law not related to the unhoused people that we're trying to help that would prohibit the occupancy, then we're not going to change that. And maybe there really is a building code somewhere that says you can't have more than one occupant per 200 square feet. We just couldn't find it in our research yesterday and this morning. So if you can find a code, then you could enforce it. I just don't think you're going to find one that's going to accomplish your goals. So anyway, that's all I've got.
Okay, so the first question is kind of a follow-up to that, Ken, which is, does housing limits affect parking limits?
Well, I would say no. And we've seen this as a problem in communities for a long time where there are not enough parking spaces for the number of cars which show up every day because of the number of people living in them. And, we've seen clients where there are 5 different owners with 5 cars and they fill all the guest parking spaces. So this is not a regulation about parking. It's a regulation about people living in the units. You're not going to be able to stretch it into, if you can't park a car, you can't live in the unit. So,
I would say especially because what if you're a family of all related people and you have 3 kids who can all drive and you have 3 cars and all of a sudden you have 5 cars? I don't think it would get around that. So another question that was submitted was, a board wants to know if it is appropriate to knock on the door of a resident to let them know that they are a member of an HOA and that there are assessments that they are responsible for. The owners have not responded to letters from management. They have not provided phone or email, and the HOA wants to let them know before they go down the collection path. From a community engagement perspective, it is always nice to meet your neighbors. An owner should have been provided with the governing documents when, and if not more, when they purchased their home. But maybe they didn't. So a non-confrontational path may be to go and introduce yourself and welcome them and get their contact information for community information, and maybe in a less confrontational way, let them know that there are assessments that they're responsible for. But it may also be that they're ignoring the letters and more escalation is required. Ken, do you have anything to add?
well, we have seen situations where there were language barriers and people moved into communities honestly not knowing that they had any obligation to pay any dues because they didn't speak English, didn't read English. They're often using a interpreter who is a real estate agent whose only goal is to sell a home. And, we even had a condominium association where a family moved in and they just had no idea they had to pay to get water and insurance and the roof on their building repaired. It's, not just a language, it's a cultural thing because where they moved from, property was handled differently. So I think it's certainly reasonable to attempt a knock on the door and a reminder or a welcome to the community kind of thing and make sure they understand. Yes. So,
All right. The next one is, what is the difference between a deductible and a loss assessment?
well, I'll take a stab at that. So the deductible, it relates only to the contract of insurance between the association or the policyholder, whether it's the association or the individual, and the insurance company. So the deductible is a part of that contract relationship between the insurance company and the policyholder. A loss assessment is between the association and a unit owner and is not related to the insurance policy at all. The difference or the connection might be that the loss assessment is measured by the dollar value of the deductible. But there's certainly some loss assessments that can be made against an owner which are different than the deductible amount. They may be a fraction of the deductible amount. They may be for a loss which has no insurance. If there's no insurance, there's no deductible. The term loss assessment also is sometimes used in insurance policies to refer to a specific kind of assessment, which is an assessment to owners to pay for common elements where the insurance proceeds were inadequate. And so it is a loss assessment insurance is usually specific to an individual owner's policy, and it is an optional coverage to pay for an assessment to all owners to pay for damage to common elements, which is not covered by the association's insurance proceeds.
All right. The next question is, I wanted to know the issues about hiring casual labor paid by an owner and reimbursed by the HOA to do basic gardening work. Our management company requires vetted vendors. What are our options / risks? Well, my first thought is that perhaps the association should be the one exploring the casual labor rather than having an owner pay for it and then reimburse the owner. Depending on the work performed, lower risk jobs that you need done around the association can be done without necessarily a vetted vendor, but there are risks about the work that they perform that come with that versus having someone who's more vetted. Like a landscaper who comes once a month versus a day laborer who comes for a few hours to do the work. And those carry different risks in terms of what obligations you'll owe, and then also what work you could get and your options for recovery if you don't get the work. Ken, do you want to elaborate on anything?
Well, the biggest risks I think of when we talk about either volunteer labor or the undocumented day laborers, whether they are citizens or not citizens, you're trying to avoid paying all of the government required taxes and insurance for labor and industries and things like that. So the two factors that are, I think, most important are, one, damage which that person might cause to the association, and two, an injury which that person might suffer and the association or the employer would become somehow liable for that injury. And like I said, this applies to volunteers who are doing work for associations too. If it's volunteers, you can often buy insurance from your association insurance company that will provide protection both for the employees or volunteers and for the property if those volunteers or employees damage the property. If you're going to Home Depot and picking up people to come and do the gardening work, you have really no idea, who they are, what their skill set is. You don't know whether or not they have any history of past work-related injuries. So, our normal recommendation is to clients to take low-risk options. And we don't see hiring undocumented day laborers for cash as the low-risk option. It is almost certainly the lowest price option. And so I don't fault boards for trying to balance cost against the risk and make decisions. But I do think that it's valuable to understand what the risks are, which would include potential liability for failing to report taxes or, or report income, and also the risks that the person might get injured and make a claim against the association. We have a lot of clients who have somehow this belief that it's okay to forgive a board member's or an owner's dues if they perform some services, cleaning the pool or doing some gardening or doing the bookkeeping for the association. And they completely ignore that forgiveness of the debt is considered income by the federal government and is supposed to be reported as income to the federal government on either a 1099 or a W-3 form, because these are either employees of the association or they are independent contractors. And as soon as you start exchanging money for services, one of those two relationships has to be created. And we would rather you do it in a controlled and predictable way and have appropriate documentation than just paying cash under the table.
All right, there is one more question that I will read, but I don't know if we can actually answer it in this setting, which is, if the association does not use the association's insurance policy to make repairs after a loss, does the association assess the repair costs to the owner's units that are affected and the common elements are paid by the association? So I think that this question is too specific for us to answer. We can't answer it without knowing how your documents lay out how you can assess repair costs. Without looking at your documents, sometimes you can assess costs to the owner, even up to the association's deductible, even if you don't submit a claim. But we can't answer that we don't even know what damage was and what the loss was.
Well, I'll offer, if you don't have the authority in your document to assess the costs within the deductible, you don't get authority to make an assessment by failing to submit a claim to your insurance. So you don't get any additional ability to assess costs by failing to use the association's insurance. And I know we've had a lot of clients trying to get creative, and they'll want to find some other reason. And usually the reason is misconduct, because they'll look at that sentence in the Condominium Act 6434-360 subparagraph 3, which says that you can assess costs for misconduct to an individual owner. And then it doesn't define what misconduct is. So the boards want to define misconduct as a failure to maintain your water heater. And UKIO has made it pretty clear that a failure to maintain your water heater is not going to qualify as misconduct, because it actually is now defining what misconduct means. And it's defining a process where before you can assess the cost for misconduct, you have to give notice and opportunity to be heard. And it's stating that unless misconduct is defined, meaning you have to specify what misconduct means in the governing documents. You can't just make it up after the fact based on circumstances. So I would say that almost certainly the answer to this question is going to be no, you cannot assess the cost to the owner by failing to submit a claim under the insurance policy.
All right. Those are all the questions that were submitted from the chat and that Chelsea sent to me. She sent some that were just to her. So with that, we will let everyone go probably 30 seconds early and see you all next week.